Hi, this is E.T. Supreme Court nominations, first made by the President, later confirmed by the Senate, are controversial because the Supreme Court today legislates, even though it's a job that belongs to the people's representatives. See Articles 1 and 5. The Supreme Court has even amended the Constitution. They did so in the mid-60s and 70s when they created a new right called privacy. Now, most, if not all, mammals seek privacy. Think of that oft-used phrase to emphasize the obvious. Does a bear shit in the woods? Well, yeah, he does, because it offers privacy that, say, the fruited plain does not. Leftists have proven themselves deceptive wordsmiths. So, privacy, as interpreted by, Justices Harry Blackmun, Byron White, John Marshall Harlan, translates to something quite different from, and sometimes the diametric opposite of, its popular understanding, so that a woman's privacy is guaranteed here, but not here. The court first performed its alchemical magic, creating a right, in the decisions Griswold versus Connecticut, that was 1965, and Roe versus Wade, 1973. The first case, Griswold, involved a seldom enforced Connecticut law banning sale of, among other contraceptives, these, even to married couples. That law was declared unconstitutional. The court did so by patching together the 14th and 9th Amendments in such a way as to weave that new right called privacy. Now, that's something that should be done only by the amending process, and that requires 3/4 of the states to ratify. More important, the Griswold decision left open a more serious application of this new right, which appeared in 1973. That was the year the court ruled that no state could ban abortion. Now let me interject something here. E.T. thinks that anyone should be able to buy contraceptives, married or not. E.T. believes something as serious as abortion should be the concern primarily of a woman who, one hopes, is wisely counseled by her family and physician. But E.T. also believes that the 10th Amendment, which is very clear in saying that the states are free to enact whatever laws unless otherwise specifically prohibited by the Constitution and the 14th Amendment, remains valid. And something else. Freedom is applicable to groups as well as individuals within them. Such was the understanding when congregations left England and Europe for the New World, and it was the understanding when the states united under the Constitution. Whatever you and I think regarding the court's legislating power, it exists, and it is exercised in the most fundamental ways, thus making the president's selection and Senate confirmation of new justices so controversial. This is E.T. Put your thoughts in the comment section below. Like or dislike this video, but do subscribe.